Okay, well, welcome to our May Sprintlaw webinar. And this month we'll be covering privacy essentials for small businesses. Um, for those who are not already clients, just a quick introduction to who we are. We are an online law firm designed for startups and small businesses. We have on this slide a bit of a description in terms of how Sprintlaw works. But the key aspect of our model is we offer fixed fee legal services covering all the different sorts of areas that your business may need help with, from getting your business set up to protecting intellectual property, data and privacy, which we'll obviously be talking about today, employment, and so on. And what we mean by fixed fee is, unlike traditional lawyers, our model is very much not billable hour based. We'll give you a quote upfront for your services, and that's kind of the cost. And we have an optional membership. About 90% of our clients sign up to it. It's a great way to build an ongoing relationship with us. As part of that, you get access to unlimited quick calls with our lawyers, discounts on our services, and a bunch of software tools. And we're actually in the process of upgrading a lot of this membership at the moment. So for anyone interested in signing up, now's actually a pretty good time. A bit more about us. We are a team of a bit over 50 staff. We have actually about 7,000 clients now, lots of positive reviews. We're in Australia, the UK, and New Zealand, and we have won lots of industry awards. So to get into the content for today's session, we're going to be covering 4 high-level topics. First of all, we'll just be talking about why you should care about privacy, particularly for smaller organizations. What's the importance of privacy compliance, and why does it matter? We'll then go through your different legal obligations, both generally in peacetime, as well as if there's a breach that affects your business, what you may have to do if that occurs. We'll briefly touch on some other protections, non-legal in nature, but also very important for privacy compliance. Finally, we'll wrap up with a bit of a survey of some recent changes that happened late 2022, early 2023, and then there's a lot of discussion at the moment about some upcoming changes to privacy laws, which may pass into law either this year or early next year, and we'll talk about the implications of those as well. As I'm going through, we've got a chat. Do feel free to drop questions anytime, and I'll do my best as I'm going through to answer them. I'll keep an eye on it. And I do like to answer questions kind of mid-presentation. I'll leave a little time at the end if we get any, but if you've got a question, just drop it in the chat and I'll try and cover it. I think we already had a question. Will materials covered today be available after today's session? Yes, we're going to circulate, I think, a recording of this and potentially also a copy of the slides as well. So that's the answer to that one. So kicking off, why should you care about privacy? Why should you care about data protection? Well, there's a few reasons. First of all, threats are increasing. People are probably already seeing in the news more and more, cyber crimes being covered. Lots of information is stored digitally now. And this means that a lot of the theft that happens in society is also happening digitally. And so protecting data, protecting personal information is becoming even more important as these threats increase. And related to that, customers care more. Certainly, we've seen at Sprintlaw an increase in the number of clients that ask us questions about how we handle people's personal information. As people are becoming more and more aware of how much of their information is available online. It is a thing that individuals, customers in all industries really are starting to develop an awareness about. So it's important to be aware of that. Enforcement is also increasing. In the past, in Australia, the privacy regulator was colloquially referred to by lawyers as the toothless tiger. It had a whole bunch of powers, but it never actually enforced any of them. In the last few years, there's been a big shift in enforcement actions, not only against larger businesses, but increasingly against smaller businesses. We've also seen that globally. So these privacy laws that in the past businesses could kind of ignore and feel like they might not get caught, that era is kind of ending. And laws are changing, as we'll talk about at the end. We saw in Europe and the UK, the GDPR in 2018 was a major change in the way that privacy regulation was approached globally. There's the CCPA in California that I think came out in 2020 And again, a lot of this stuff is putting a lot more onus on businesses operating digitally to comply with personal information. The Australian Privacy Act hasn't had as big an update, but as I mentioned, we are looking to. It's looking like we're going to follow, in the path of the GDPR and the CCPA in the next year or two. I just wanted to also touch on the Medibank and Optus breaches, because obviously this was a big news item a couple of years ago in Australia, and has, I think, led to the current sort of regulatory push for change around privacy. People may recall in 2022, Optus was the victim of a big cyber attack. A lot of customers' personal information was taken by sort of ransomware hackers, names, date of birth, driver's license, Medicare cards. What happened? We still don't know the full details, but it looks like it was caused by a cybersecurity vulnerability, and it was in part just due to human error by the IT team leaving an API open. Medibank as well also were subject to a ransomware attack around the same time, and a ton of customers' data was leaked on the dark web, and anyone that was a Medibank customer would have received one of those notifications if they were affected. And so, a similar thing, customer names, Medicare numbers, policy numbers, all of these were leaked. And again, it was just due to criminal activity. And a super simple explanation, it seems like, with Medibank. It was just a theft of username and password. It wasn't something particularly sophisticated in terms of what was at least the core cause of the data breach. So, these, I guess, are examples of things that are happening, and observing obviously what happened, and obviously those are larger organizations, but what happened to both Optus and Medibank, the cost of a breach can be major reputational damage for a business, and irrespective of legal liability and fines and those sorts of things, at its core, those brands lost a lot of trust from their customers. They lost a lot of customers, and it'll take them many years to recover. And certainly for your business, if you're in a situation where you're suffering some sort of cyber event, cyber attack, and it's due to some negligence on the part of you or your organization, it's not a great look for your customers, and for the trust, both short term and longer term, to suffer a breach. So it is something you want to think about avoiding, just if nothing else from a reputational basis. In addition, there's fines, there's legal costs. The regulators can issue fines to organizations where they were negligent. I mean, if it's pure criminal activity and you weren't negligent, it's not like you're going to get fined for that, and that's why it's important to take preventative steps, as we'll be talking about today. But you can be fined if there are steps you could have taken. And there are legal costs. Your customers may sue you for losses they suffer if identity theft flows from your data breach, or again, even in defending yourself from regulators and so on. So it can be expensive from that perspective. And then there's the IT costs. I mean, when the breach happens, you need to close the hole. You need to work out what's going on, and you may need to spend a whole ton of money on IT. So it can be a very expensive exercise, and needless to say, it's something that you want to avoid if you can. And on the other hand, the benefits of compliance with at least the privacy laws, obviously it's avoiding those three things: reducing risk of breaches, reducing the risk of fines, and so on. But there's also other commercial benefits. And this is a study done by Cisco back in 2019, which was, I think, the result of a review of over 100,000 businesses. And they were trying to measure the different advantages from privacy compliance in all kinds of areas of business. And you can see, businesses who were privacy compliant was correlated with higher levels of innovation. It gave the business competitive advantage, made their operations more efficient, of course, lower losses from data breaches, shorter sales delays, and appeal to investors. And you can imagine, customers who can see that you take privacy seriously, that you've got policies, procedures in place. It's something that you care about. It's going to help your sales conversion rates potentially. It's going to help you differentiate against competitors. It'll help probably in the process of setting up privacy compliance measures, clean up your operations. Certainly, Sprintlaw went through an exercise early on, building our personal information register to track where all of our customers' personal information was located in our various systems. And in the process of doing that and cleaning things up, we were forced to make our operations much more efficient around the way that we integrate with different systems and the places that we hold data. And it's had a big benefit on how efficient our business is. So this exercise of privacy compliance can really have benefits outside just, avoiding these breaches and getting fined. And given where the mindset of customers and regulators is going, it is just a very good idea to invest in privacy. So let's get to the legal stuff. What actually are your legal obligations in relation to privacy? Well, there's kind of three categories, which I'll go through in a little bit of detail. The first is kind of general privacy compliance. This is the peacetime stuff, which everyone can be doing right now. There's laws that cover what an organization needs to do when they collect personal information, when they disclose personal information, and the way that they hold and manage personal information. There's specific obligations at the time of a data breach. So if you suffer an event, so this is the wartime, someone comes in, steals your customer's personal information, there are obligations that you may have, some of them fairly time-sensitive obligations to notify regulators and customers about that. So we'll go through that. And finally, and this is a sort of halo of the other two, increasingly there's a view that directors of companies are actually responsible for privacy compliance of their organization, for the privacy of their employees and customers' personal information. This is not super well established in the law, but again, it looks like the law is moving this way. Those that are directors of companies should be aware, you may or may not be, but you should be aware that you have certain duties as a director of a company, to act with in good faith and with due care and skill in exercising your duties. And generally, as a company, a director isn't personally liable for issues in the company, but in the case of breaching directors' duties, there can be personal liability. And it's thought increasingly that if a director of a company isn't taking adequate steps towards privacy compliance for their organization, it could be one of those situations where the limited liability company, doesn't necessarily protect you, and directors can be fined personally or held personally liable. So we talk about this limited liability concept a lot in these sessions, the advantage of a company structure, and one of the reasons small businesses are set up with company structures is to avoid that personal liability. But given that there is this potential in this one area of privacy, for that liability not to be effective, again, it's an extra reason for directors to take this quite seriously. So we'll talk a little about that as well. So just starting with the general privacy compliance. In Australia, the principal piece of law that governs privacy is the Privacy Act 1988. Yes, that is a long time ago, 1988. It's been updated several times since then, but it is basically the main piece of legislation that protects the handling of personal information about individuals in Australia. And it really covers what we need to do when we as an organization are collecting personal information, using it, storing it, and disclosing it to other organizations. And this act covers both the public sector and the private sector. So for smaller businesses, a question is, how does this act apply to me? How does it affect my organization? So one of the somewhat surprising aspects of the Australian Privacy Act is that we have a sort of general exemption for any business that's generating under $3 million in turnover. The compliance with this act, in general terms, is actually optional. You don't have to comply with this act. It's called the Small Business Exemption to the Privacy Act. And it's a fairly significant exemption because it applies to lots and lots of small businesses. And sometimes I quote this to our small business clients and they go, great, I don't have to think about privacy anymore. I'm in that category. If you are in that category, I wouldn't suggest quitting the webinar now because there are many reasons why you still may want to think about privacy. But certainly if you're over 3 million in turnover, you absolutely do have to comply with the Privacy Act. If you're under, there's a few important points to clarify around that. There are exemptions to the exemption if you collect certain special categories of personal information. If you collect health information, if you collect sensitive information, tax file numbers, and other sorts of things, and you're under 3 million in turnover, you still have to comply. And so that captures a lot of organizations who are in the under 3 million bucket. The second point to make around the $3 million turnover cap, if you're an organization that's under 3 million today but expects to be over 3 million tomorrow, the day that you hit above 3 million, you will need consents from all of your customers, and we'll talk about how that works in a moment, to continue to use their personal information as you are. And if you haven't been collecting it since day one, then you may find yourself in breach just when you exceed that $3 million mark, and it can be very complicated to become compliant when you weren't from the beginning. So it's a lot easier to be compliant actually from day one. And thirdly, it does look like, and we'll talk about this at the very end, that this $3 million limit may be abolished within the next 12 to 24 months. It's not confirmed, but I do expect it to be. So again, it's somewhat a relic of the previous era of privacy regulation, and under the GDPR, CCPA, and all the newer privacy regulations around the world, there's no such exemption. So I wouldn't get too excited about the exemption, but it is there, and something that it's worth pointing out. But otherwise, if your business handles personal information, you need to be thinking about the Privacy Act. Now, just to zoom in on this term, personal information is the key concept in privacy law. It's information about an individual that could be used to identify them. So when we're talking about privacy, we're talking about names, addresses, phone numbers, emails, passport details, whatever it is. If there is a single piece of data that someone could look at it and go, oh, I know who that's about, that's likely to be considered personal information. The definition of it may be expanding. Again, we'll talk about that at the end, but in some other jurisdictions, it's expanding to cover things like IP addresses, which you may not know who it is from reading the number, but there's stuff you can do with that. But in Australia and in most definitions of personal information, we're talking about a piece of data that can be used to identify someone. So anytime you're dealing with that stuff in your head, you should be thinking, okay, this may be the domain of the Privacy Act. So that's the Privacy Act. In order to comply with the Privacy Act, there's a few areas that you may want to think about. The first is your privacy documents. The second is setting up procedures for those data breaches I mentioned. The third is access requests, which we'll talk about. If someone asks you, what are you doing with my personal information? What do you need to do? And then, we'll cover some other non-legal tips. So just to talk about the documents and that are required for compliance with the Australian Privacy Act. So the Australian Privacy Act begins with this statement of Australian privacy principles, which is a little wishy-washy. And it says, to all businesses that are covered by the Privacy Act, you must handle people's personal information in accordance with these 13 principles. And I won't go through all of them, but you can see on screen that things like transparent management of personal information, the way you deal with unsolicited personal information, who you notify when you have it, the way that you keep them secure, how you deliver information overseas, direct marketing, etc. So it is a little wishy-washy because the Act says, oh, you must comply with this Act, and then it says you must adhere to these principles. And it's not very helpful for a small business, being told you need to adhere with principles, because there's no sort of checklist of things you need to do to tick off these principles. Now, the Act was kind of purposely designed this way to be future-proof, because if they developed a checklist of documents that you need and the landscape changes around personal information, then the Act quickly becomes outdated. So that's why they adopted a principle approach. But again, it's difficult to establish without further information exactly what it means for you to be open and transparent about the way you handle personal information. Now, fortunately, through convention and over time, lawyers have helped design a suite of common documents. Some of them are, in fact, mentioned in other areas of the Act. Some of them are not mentioned in areas of the Act, but are good practice. And it's basically considered that if you have and I'll go through these in a bit of detail, but if you have the documents listed in the kind of third column on screen, you are generally going to be in a pretty good spot to say you're complying with these principles and you're complying with the Privacy Act. So the first is a privacy policy. Most people would have heard of this document. Any business covered by the Privacy Act needs to have a privacy policy. That's in APP 1, Australian Privacy Principle 1. And a privacy policy is a document that's, sets out, here is what personal information, whenever we collect personal information, this is how we deal with it at our organization. This is the types of information we may collect. This is who we may disclose it to. And this is, how you can contact us for questions about it. So that's the privacy policy. And it's a somewhat template doc, but it does need to be tailored a little to your business based on what kinds of information you collect and what your operations are. But that's one of the pillar obligations of being covered by the Privacy Act and for compliance. The second is a privacy collection notice. This is a notification at the point that you collect personal information that you are collecting it and notifying them of what you're going to do with it. So anytime you collect personal information, you should have a statement that says, this we'll collect your information. We're collecting your information for this purpose, and we'll use it in accordance with our privacy policy. A collection notice can be a fairly simple statement or a lengthy statement. It depends on the context. Often you'll see it on websites. Someone's got an inquiry form, name, address, email, message, and then at the bottom there's a tick box. We'll use this information to contact you, and for other marketing purposes, in accordance with our hyperlink privacy policy, tick here for consent. And that is the collection notice. That one sentence, it would be considered a collection notice, and then it would link back to the privacy policy. But if you're collecting information offline, where there isn't an easy hyperlink to the privacy policy, for example, you run a medical clinic, or you have physical onboarding for your clients, and you're collecting their personal information. Again, you should have a statement on those paper forms if you use them, saying, we're collecting this information in accordance with our privacy policy. And you may actually, on the collection notice, summarize the privacy policy. The goal here, of course, again, with APP 1 and 5 is to just be clear about what you're doing with the information that you're getting from people and how you're going to use it. And so you just want to make sure at any point of collection of this personal information with your customers, you're being quite clear about what you're doing with it. And that's the purpose of these privacy policies and collection notices. Mel's just asked, will we be covering guidance on seeking cookie consent upon landing on a digital property? Great question. We will briefly touch on the law around that at the end. But interestingly, in Australia, there's not currently any requirement to obtain cookie consent under the Australian Privacy Act. It's a GDPR EU-UK concept. It may apply to Australian businesses operating in those regions. If you've got a UK or European website, then the cookie consent becomes relevant. It's good practice to do anyway, but it's not currently required by Australian law. It may be, though, which I'll cover at the end, a new requirement next year to actually think more about cookies and how you handle them. But yes, it's not currently a feature of Australian law. And if you actually go onto Sprintlaw's Australian website, you'll notice we don't have a cookie pop-up, but if you go to our UK website, we do have a cookie pop-up. So it is actually a difference in regions. Katie's asked, is there a difference between customer data and employee data with regards to privacy laws? Another excellent question. Yes, there is somewhat a difference. The definition of personal information is not specific to customer data only. So all of the ways that you handle personal information, your privacy policy, collection notice, do apply to the way you handle both employee data and customer data. There are, however, some additional obligations around employee data. I don't have a detailed coverage on them in this presentation, but to the extent that you collect employees, salary information, tax file numbers, some of that stuff, there's extra requirements to keep it particularly secure. under employment laws and a little bit under the Privacy Act as well. So in general terms, there's everything I'm saying today will apply to both customer and employee data, and there's a couple of additional protections and safeguards in the law for employee data. A couple more questions. Mel's asked, we've noticed that even our clients' sites were getting traffic from EU and CA, so I wasn't sure how to handle. Thanks for your explanation. From EU as well. Yes. Yeah, it's an interesting question on what if you're an Australian business and you get visitors from other countries? Do we need to comply with all these privacy laws in relation to those customers? It's actually quite a complex question to answer. It kind of depends on your model and which countries are coming from. But the general principle is if you are specifically operating and targeting in other countries, then you are generally required to comply with their local laws if you're conducting business there. If you've just got an Australian site and someone on the internet who you're not actively targeting with your goods and services is visiting, or it's incidental, it's unlikely you will have to comply with international privacy laws. And so for the majority of our clients, until they actually launch a European business or a US business or actually expand internationally, it's usually sufficient to just have your Australian privacy compliance sorted and then consider that as you expand into other regions. Lauren's asked, I receive medical referrals from GPs before a person becomes a client. How can I safely manage their personal information when I haven't sent them my privacy policy and collection policy to agree to at that time? So you should, at some point in the client onboarding process, have a form where you're getting them to confirm their personal information, and you should be including a collection notice on that form. And that's, again, what I was alluding to with those examples of collection notices. It will depend on your business where you slot that in, but at the point of collection, I mean, if you receive the unsolicited personal information just over email, here's my client's name and address, then that's not necessarily a point at which you need to collect the consent. But when they are becoming your client, you should have some process, formal process, whether it's digital or physical, of saying, what's your details, and then a statement saying, we will handle your information in accordance with our privacy policy and use it for the purpose of X, Y, Z. You can link to your privacy policy. You can, which on your website, if it's easy for them to access, even if it's a paper form, or you can reproduce it. But that's typically how it's handled in a medical context. And obviously, our team is very happy to talk through your specific information in more detail if you have questions. And then Gareth asks, is there a distinction between collection and receipt if a client sends me new staff information to onboard via email versus using form? If you just receive, as I was kind of mentioning, if someone just sends you personal information, which you didn't specifically go out and request, you may not have these obligations around collection, to make sure that you've gotten consent before the email was sent to you. Obviously, it's not practical for you to tell everybody, don't email me any personal information until everyone's, signed a collection notice. So yes, there is a distinction there, and often there's, chains where people's emails are CC'd. It's about if you're out there collecting personal information actively, for a purpose, and usually it's, you're collecting leads for your business or clients. At that point of collection is when we need, the consent, the collection notice, and the privacy policy. So, yeah, hopefully that kind of answers the question that you were getting at in terms of collection versus receipt. So yeah, some good questions on these two documents, the privacy policy and collection notice. And again, these are really the big two to focus on for most smaller businesses. If you are covered by the Privacy Act, you need them. They're mandatory. They are, I said this is a principles-based approach, but these are the two that are quite explicitly mentioned in the Act. Even if you're not covered by the Act, I already mentioned the reasons why you might want to have them anyway. So if you don't have up-to-date versions of these already, definitely add that to your to-do list. The other documents are best practice documents for compliance with the other APPs. So there's something called a privacy impact assessment. the APP or principle is about making sure that your organization only uses personal information for a purpose for which it was collected. So if you've told someone, I'm only going to use your personal information for marketing and promotional purposes and for the purpose of providing you goods and services, but then you go out and use it for some other purpose, you're obviously breaching what you promised in your policy. So, and this is an issue for a lot of organizations. They tick the box with the privacy policy and the collection notice, but then they don't actually implement all their promises in the privacy policy. So having a document which just covers your operations and looks at how you are collecting personal information, using it, and making sure that it's consistent with what your privacy policy says is an important exercise to do every so often. So something that you can do formally with lawyers or just internally, just review your operations and make sure that it's consistent with what you're saying you're doing in your privacy policy. If you engage in direct marketing, basically directly contacting individuals, you can't do it unless you've got specific consent. That's different to sending email messages and those sorts of things. But the door-to-door individualized knocking and that sort of very, very direct marketing, telemarketing, is not something you can just use people's personal information for without specific consent. And again, you may want to have a policy around specifically how you do direct marketing if it's part of your business model. There's an obligation if you're sending information overseas, so you're transmitting it to offshore workers, or these days most software tools that most businesses use, the servers may not be located in Australia, and so in a sense your data is going overseas anytime you collect stuff in your Gmail account or whatever it is. Your organization has a requirement to make sure that the overseas places it's going to are not themselves breaching the privacy laws. You may be very compliant, but your subcontractor or your vendor is not very compliant. And if they've got access to your customers or employees' personal information, that could be a breach of APP 8. Best practice, obviously the larger organizations like Google and so on have very comprehensive privacy policies, so it's not a massive risk. You don't need to go negotiating with Google, hey, improve your privacy policy for me. But for the less sophisticated organizations or less large in scale organizations, you just want to build in a practice of making sure that they're treating your organization's personal information with the care that is required by you. And typically you can just include a clause in any of your contracts, a privacy clause that says, you, the contractor, or you, the supplier, or you, X person who's handling our personal information of my organization, promise you'll comply with the Australian Privacy Act in the way that you handle it. And of course, making sure that they will. And that's a good way of showing compliance with this overseas care requirement. 11 is about data breaches. You've got to take steps to make sure that personal information your organization holds is protected from misuse, interference, or loss. And again, we'll talk a bit more about data breaches, but having policies in place. What do we do if there is a breach? What steps are we taking to prevent a breach? There's a document that's commonly created called a data breach response plan that covers some procedures that an organization may have in place. And again, just even having that document is a great way to show that you are taking steps, and a good thing to invest in to show that you're taking steps towards protecting personal information. And finally, we've got on here the access request guidelines. So there's an obligation under APP 12 if individuals request to you, what privacy data do you hold about me and what are you doing with it? You generally need to comply with that. With some exceptions, you need to have a point of contact. So having some guidelines in terms of what you can and can't provide and how you're going to respond to those requests is also a good thing to have to show compliance with APP 12. So look, this is, I think, a good overview of your peacetime documents. I would be surprised if everyone in this webinar has every single one of these documents, and the majority of our clients don't have them all, but most large organizations do. So that's the best practice, to have all these, and there's a couple of others as well. At minimum, I would suggest 1 and 2, privacy policy collection notice. I think it's a very good idea to build that practice with your overseas recipients of making sure there's privacy clauses. Data breach response plans are also important. and to the extent you can, reviewing your operations with that impact assessment to look at how you're handling personal information and where it is. Is it spread out across 50 different apps, or is it only in your emails and one or two other systems? Where is it? Map that out and make sure you know how you're using it. I think those are all important steps to take at various levels of formality. So hopefully that's helpful for people trying to understand how you comply. But yeah, we'll dive into a couple of other things. So this is all, I guess we've just been talking about the Privacy Act, which is the principal piece of privacy legislation in Australia. Unfortunately, while we wish the law could be simple, there are a ton of other acts or regulations that aren't the Privacy Act that apply, some at a state level and some at a federal level, which also cover personal information. So it's just worth being aware that there may be extra stuff you have to do. I won't go through all of them in detail, but people will be in various industries. Some industries, some areas have extra privacy laws under different acts. So for example, if you're dealing with the personal information of minors, New South Wales and other states have equivalent acts, has the Child and Young Persons Act, which talks specifically about the handling of youth personal information. The email marketing laws, this is a federal law that applies to all Australian businesses. There's a Spam Act 2003, which talks about when you can and can't send unsolicited emails, and covers your newsletters and your automated emails that your organization may send. Requires you to have unsubscribes and follow some procedures there. So it also kind of covers personal information. Very important if you're doing email marketing to just check out the regulator's website and understand a bit more about how spam law works. There's the do not call register. If you do outbound telemarketing, you can't call anyone on a specific register. If you're surveilling your employees, whether it's through video or even if you're just listening into their calls without them knowing or with them knowing, there's laws about consent you have to get from your employees. And similarly, if you're recording phone conversations, there's laws in most states, around, and people would have heard the message, this call may be recorded for quality and training purposes. There's legal requirements to inform people of that. So that stuff's not under the Privacy Act, but a good overview of some of the common other areas where privacy may come up. And again, for your own specific industry, it is worth just double checking if there's specific laws around the kinds of stuff that you're handling. Just noticed a question from George. What's your responsibility related to using something like Salesforce and Australian contact details and breach? We rely on them to protect info, and does that protect us? That's a really good question. And I guess comes to APP8 I was talking about before. Salesforce, their servers may or may not be located in Australia. If anyone's using Salesforce or any CRM, really, Pipedrive, whatever it is, HubSpot, you will have a ton of your customers' contact details in these apps. Same goes for Gmail. The same goes for Microsoft Outlook. So if those companies suffer a data breach, it is very possible that your customers' personal information will be at risk. Now, first of all, and we'll come to the data breach requirements in a moment, you may have obligations to inform them as soon as that happens. For example, there's a company called Typeform, some people may be aware of. We had a lot of clients using Typeform to collect people's personal information. And back in 2018, they suffered a data breach. And we advised a lot of our clients that they needed to tell their customers, we're really sorry, we used Typeform and there's been a breach of your data if they were affected. So yes, if Salesforce is hacked, you may have some obligations to tell your customers. A second question is, are you liable? You may feel it's not my fault that Salesforce got hacked. They're a large organization and I would have expected them XYZ to have procedures in place to protect my small organization's data. There's merit to that argument, and certainly I think if it was presented to the regulator, it's unlikely they would expect a small business to do considerable due diligence on Salesforce to make sure all of their procedures and processes were in place. If you could show that you had at least kept a copy of their privacy policy or reviewed it, and you took steps as soon as it happened to inform your customers, it's still going to be a headache for you. It still might cause you to lose some trust, but you won't necessarily have legal liability. The only aspect I would make clear is, and this is certainly the case with people that use Amazon or Microsoft, there are settings in those softwares around how secure you keep people's data. So, and I'm not sure about Salesforce, whether there are toggles in the account management settings But to the extent there are, and you've negligently left them all open, made every link public, with Google Docs, they can be shared publicly or privately. If you've left personal information shared publicly, accessible via links, despite the fact they're big companies, because of the way you've controlled their data and configured it, you could potentially be liable for some negligence there. So I do think you can't just rely on the fact it's with a big company to just go, oh, it's their problem, not mine. You are ultimately liable. It does help that they're big companies, but definitely be aware of, configuration settings and those sorts of things, which could make you liable for negligently using the software, if you will. Couple more questions. Are there any particular privacy considerations when doing outreach for leads generated via LinkedIn, sales flow, etc.? Yes, there certainly are. There's not only the obligation for before you whoever collected that personal information, whether you got it from a partner or maybe just from using a mining tool, some kind of consent needed to be there for you to be able to use it for an outreach. Now, on things like LinkedIn, in their terms and conditions, people that sign up to it generally consent to be contacted in accordance with the platform's functionality. So you've kind of got that kind of consent already in the platform. But if you're buying lists or getting leads from other sources, you want to be asking people in this list, are they expecting and have they consented to receiving the messages from me? Because if they haven't, actually the collector could be in breach and you too could be in breach. And finally, with the Spam Act, which I briefly touched on, there's laws around, and you can just go onto the regulators, ACMA, it's called, website. It's got guidelines for how to do cold outreach and when consent's required. So you want to make sure you're not breaching the Spam Act. And I think often you can make an initial communication to a generic address, but you've got to have unsubscribes and so on. So definitely an issue, and we give a lot of advice around the cold outreach. So something to look into if anyone's doing that. I guess quite a few questions here, so I might deal with about half of them and then kind of keep going through. But I noticed Keston's asked a follow-up question. Lead referrals from leads placed directly via website and referred to partners. Yeah, again, you would need to, on any form where you're collecting personal information, whether it's a partner's website or your website, there needs to be a collection notice and a privacy policy. There is the exemption, of course, for the under 3 million businesses, but in general terms, that is a point of collection. You need a collection notice and a policy, and the disclosure that it's being referred to partners. Katie's mentioned, to add a little on the overseas service topic, heads up that some Australian government orgs are now requiring suppliers to confirm their customer data is stored within Australia. Not easy with Dropbox and Google. Yes, that's very true. There are some more stringent public sector requirements, which I'm not covering today on the Privacy Act, but for businesses that have government customers, not only are there more stringent laws that apply to them, they generally have gotten quite good advice from privacy lawyers and ask a lot of questions for organizations. Where is your customer data? Do you have these documents in place, et cetera, et cetera? So I think this is a good point. And again, if you've done all of the stuff here, or even most of the stuff here, it comes back to that point of helping your organization engage better with your customers, build trust, and potentially win tenders if you need to for government organizations. Okay, I might just continue on, conscious of time, but if I get time, I'll go back and revisit some of the questions I haven't yet answered. So let's talk about data breaches. I've been alluding to this for a little while, that we're going to cover, what to do if there is a data breach. Look, I guess most organizations are scared that one day there will be a ransomware attack on their data, or some other breach that happens. Maybe you'll have a negligent employee that accidentally sends your customer list, all over the universe, or some other incident occurs where data has been breached, personal information has been leaked in some way. So there is specific laws around how to handle this data breach situation. Now, again, this Data Breach Act, section, it's a section of the Privacy Act. This data breach section of the Privacy Act has the same small business exemption currently, So these requirements are less stringent on businesses with under 3 million revenue. As I said, still good practice to comply with, and may be abolished pretty soon. So still pay attention if you're in that category. But if you're over 3 million in revenue, you really do need to comply with this, or there could be fines. And the Act is a little less principled here and actually sets out some fairly, not completely, but fairly clear steps that you're required to take if you suffer a data breach. So we've got, contain, assess, notify, review are a nice little summary of the 4 steps. So contain, first thing you have to do is make sure that you take steps to mitigate the data breach. So what the regulation wants you to do, if you find out that data has been breached, stop it first. Can you hire IT experts to get involved and patch the hole? Can you revoke whatever it was that caused the issue? What can you do to mitigate the damage caused by the data breach? So again, a common sense thing to do, but there's a positive obligation for you to take whatever steps you can. And again, later on, the fines and penalties could be much higher if you just go, oh, it's happening, and you don't take any steps to try and contain it. So containing is very important. Step 2 is to assess the damage done. Now, the Act is quite reasonable in the sense that it doesn't require you, if one email with someone's personal info went to the wrong person that it shouldn't have, and it's unlikely to cause any damage to the person whose data was technically leaked in that situation. The Act doesn't require you to tell every single person about every single little breach that happens. It wants you to work out who was substantially affected by this breach, and is there a substantial likelihood of there being some impact on that individual. That substantial impact test is quite qualitative. You probably want to chat to a lawyer to work out if it is in that category. But losing people's passport TFN numbers to a ransomware attack is obviously substantial impact with a high likelihood that something's going to go wrong. Losing people's email address, name, and address in an accidental forward is probably low likelihood. And there's everything in between, and that's where it gets a little gray. So you got to assess the damage. Now, if one person's affected, you still may have to notify that one person. If there's a large volume of people affected, you either have to work out who was affected and tell all affected people, or if that's really hard to do, you've got to do a mass either email send or post something on your website if you can't do a mass email send. So there's laws around who you have to tell and how you tell them. But it is about assessing. And so I've kind of blended into step 3 here, which is notify. So you do have this obligation. Anyone that's been substantially impacted by a data breach, there's an obligation on you, the organization, to tell them about it in some way, whether that's through email, phone call, or where that's not practical, a message on your website. It's something you have to do. Now, not only do you have to tell the individuals, if it is in one of these situations where there's a substantial impact, you also have to notify the OAIC, the regulator. Hey, we X organization have suffered a data breach, and we've taken these steps to contain it. We've assessed the impact, and we're sending these notifications. You've just got to let them know, and that's again a legal obligation. So this has to be done quite quickly. There's not a specific 24-hour, 48-hour timeline, but it is quite explicit in the law that you have to do it as soon as reasonably possible. So again, I don't think people necessarily have to memorize all of the tests for how something is, whether something's substantial or not. But it's very important, I think, for all business owners or people working in organizations managing this stuff. If there is a data breach, you probably want to reach out right away for some legal help, because there is a time element to it. Now, the majority of advice we give on this topic, it is a minor data breach. People are worried. And it's a handful of customers who really there isn't a substantial impact in our view, and this means that you end up not having to even tell anybody, or you can tell them for courtesy if you like, but there may not be a legal obligation. So don't think that this is going to be something that takes over your business. But if you do suffer one of the more serious attacks, you want to be ready, and it's always best to err on the side of caution. So be aware if there's data breach, there's stuff you need to do. If that's your only takeaway, that's still helpful. And then after you've made the notification, you have to take active steps to review your policies to prevent a reoccurrence. If you do 1, 2, 3, and 4, and you do it well, and you weren't particularly negligent before in the way that you had your policies set up, you are unlikely to receive a substantial fine, and your potential liability to customers will be a lot lower. So whereas if you do none of the above, your risk ends up being much higher. So that's why it's important to comply with these processes and be across the data breaches. Then just moving on to access requests and complaints. I mentioned earlier under one of the APPs, there's a requirement that you have allow people to contact you and ask questions. What are you doing with my personal information? And how are you holding it? So at the bottom of every privacy policy, there should be a section where you list the contact details of your nominated privacy officer, which, if you're a small business, may just be the business owner, or it may be someone you nominate in the organization, or it may just be a contact email. But there must be a mechanism. I think we have privacy at sprintlaw.com.au, for example, for individuals to contact and ask, what are you holding about me and what are you doing with it? Individuals can make complaints if you're not complying with this to the privacy regulator, and fines can be issued if you're not complying with these access requests. The individuals have to follow these 4 steps before they can complain about you. They've got to first make a complaint in writing. I want to know what you're doing with my information. I suspect you used it in a way that I didn't approve. You've got a reasonable time to actually review and respond. And if they're not happy, they can take it to a dispute resolution scheme or make a complaint to the Information Commissioner. Now, we don't have an explicit right in Australia to be forgotten. In Europe, people may have heard that any individual can contact an organization and say, I want you to wipe everything you hold about me. And there's this explicit right in the GDPR that says there's a right to be forgotten, and individuals can be forgotten by organizations. That does not exist in Australia. We do have to respond to requests and be transparent about how we're handling people's personal information. We don't necessarily have to wipe everything. That may change in the next year or two. So, just be aware of that. And in practice, you may still want to comply with wipe requests if you can, but it's currently a little less intense. It's more that you just have to respond to these requests and be pretty clear about what you're doing, unless there's a good reason not to be. So yeah, that's how the access request process works. So if you haven't already, set up an email address in your privacy policy and just be aware that, and you can direct any customers to contact you there for questions about privacy and your organization's handling of it. And yes, as I mentioned, you can, in certain circumstances, refuse an individual's request if there's a good reason that you don't want to reply to whatever they're asking. So you don't have to comply with it every whim in terms of disclosing all of your internal operations under the guise of privacy, but you have to kind of comply with these reasonable requests. Finally, I just want to cover some non-legal things. We've talked a lot about legal documents, procedures that you need to have in place if there's a data breach. And these things are all good for legal risk management, for taking sort of practical legal steps to reduce the likelihood that you'll be fined. But there are many aspects of data protection that have nothing to do with lawyers and are also very, very important things to look into. So first of all, you may want to get cyber insurance. In the worst case where there is a data breach, you are fined. You do your best, but you are found to be negligent. There's ransomware attacks that you may need to pay, whatever it is. There is pretty comprehensive insurance policies out there which can help cover not only the legal cost of advice you may need, but also the business loss. It's I think increasingly an essential insurance for a lot of businesses operating digitally, and even some of those that don't. And again, at Sprintlaw, we certainly have comprehensive cyber insurance. So I would suggest those that don't have it, look into that. It's not something that we offer, but there are plenty of vendors out there. Experts, cybersecurity reviews. Again, you may want to appoint IT professionals to review your systems, check for leaks, check for holes fairly regularly. This is going to reduce the incident of a cyber attack. Again, it's good practically to reduce the risk. It's good for your brand. And also it's going to be actually good for compliance to show that you're taking active steps to protect people's personal info. So that's more of an IT thing, but something, again, that you can do. Keep track of where people's personal information is in your organization. I talked about that impact assessment. It can be hard to know operationally where is everybody's email and contact info in my system. I use 10 different apps. So just be aware of where it is, map it out, and see if you can reduce the points of failure. Again, a practical step you can take. Security training. We run this at Sprintlaw for all of our staff. Once a quarter, we send out quizzes and tests to stop things like phishing and human errors that may cause privacy breaches. I mentioned at the start of this presentation, Optus and Medibank, both a result of human error, in part at least. So we talk a lot about protecting our systems, locking down everything, but really it's actually the people in your organization that may be the source of many of the vulnerabilities. So investing in training is not only good to prevent risk, but also is going to show you taking steps to protect people's personal information. And finally, you may want to have information security policies and processes, just setting up day-to-day processes for how your staff treat and handle personal information. Setting up rules, don't forward lists to people that aren't in our organization, et cetera, et cetera. Things like that can also help reduce the risk. That's the extent of a lot of the legal material I wanted to cover. I'm conscious that we're at 12 and I've got a few questions, so I'm going to go a little bit over. If people need to drop off, of course, there'll be recordings. If you've asked questions and want to stick around, I'll cover them in the next 5 to 10 mins. And I've only, I think, got 2 slides left. I just want to quickly cover the 2022 law changes and the 2024 potential law changes. So just to quickly talk about the 2022 law changes, there was an act that was passed right after the Medibank and Optus breaches, and it's one of the most significant reforms we've had to privacy laws in recent years. And it expanded the reach of the Privacy Act. So overseas businesses that are doing business in Australia or have a link to Australia have to comply with the Privacy Act now. They increased the penalties for enforcement. So I talked about how the regulator was previously criticized for being a toothless tiger. These days, it's getting some teeth in terms of what it can do. And there's significant fines. You can see up to 2.5 million for individuals and up to 50 million for businesses. And that could theoretically, it may not be that high, but could theoretically apply to smaller businesses as well. So there is significant penalties now and increased regulatory powers as well. So the Privacy Commissioner can actually work with other agencies, with ASIC or other regulatory bodies to share data and figure out whether organizations are breaching data protection and privacy laws. So that's all come out quite recently. And again, I think we'll see a lot more activity in the privacy space. And 2024, there's a big privacy review happening at the moment. It's been going on for about a year, even a little longer. And the government's actually agreed in principle to a ton of changes to the Privacy Act and just have to go through the work of legislating it. So some of the recommendations they're still getting consultation on, but some are pretty much agreed that they're going to happen. So this is kind of what's coming. I mentioned already a few times, it's looking like the small business exemption will be abolished. That's one of the ones that's not confirmed, but there's considerable discussion around it. So again, privacy is about to become a lot more of an issue for smaller organizations. There's a talk of mandating default privacy settings for online services. So if you're operating a website or an app, you may not by default be able to collect as much information using analytics tools that you do today. And there may be some cookie consent requirements, as I mentioned earlier, similar to GDPR being introduced. You may have to be more clear about what countries you're transferring data to, particularly if it's not from a list of certain prescribed countries. So there may be more detail around that overseas transfers concept we were talking about earlier. There'll be more explicit requirements in the law around security measures that you may need to take. I covered those anyway in terms of saying here are some other tips, but it may actually appear in privacy law that you have to do some of those things. And finally, I touched on this earlier, but personal information traditionally has meant name, email, address. It may in future include IP addresses and device identifiers, again, which means a lot more types of stuff that organizations do may be subject to privacy laws. Conscious we've got a ton of questions in the chat. I'm about to go through them, but that's kind of the end of the content I wanted to cover, and I hope people enjoyed this. So let me just scroll through some of the questions. A question is a disclaimer in the privacy policy sufficient to protect your business when a third party breach happens? The answer to that question is no. I think I covered probably post you asking that question in detail what you need to do when a third party data breach happens. Both with that Salesforce example I was talking about, and also those 4 steps. So when the breach happens, you've got to comply with the breach laws. Users asked, is there any difference regarding dealing with individual consumers versus business to business? For example, regarding gaining consent for the purposes of marketing. A good question. That distinction between B2C and B2B is not a particularly big feature of Australian privacy law. It's not something where it says, this only applies to consumers and this only applies to B2B. In practice, if you're collecting people's business details, so their PTY LTD and their ACN numbers, that information is not necessarily personal information, whereas if you're collecting an individual's name, it is. So in a sense, in practice, it might be different. But ultimately, whenever you gain consent for the purposes of marketing, you're emailing an email address, whether that's the business owner, the CEO, the head of marketing, whoever it is that you're emailing, they are an individual. Doesn't matter whether they're in a personal context, a domestic context, or a business context. The Privacy Act applies to their information, so you still need the same consent. So again, some other laws differentiate between B2C and B2B, but privacy is not clearly one of them. So hopefully that answers that one. Then we've got a couple of questions. What happens and what are the risks where your telecommunications is sharing your IP address? That's probably more of a technical question than a legal one. I don't know if I'm best placed to answer it, but there are potential risks, and a lot of people use VPNs personally to protect their IP addresses. IP addresses can be used in certain ways to identify at least where a user is, and in some cases who a user is. That's why there's talk of bringing IP addresses under the definition of personal information. They are just a number to identify your kind of which web server you're active on, but yes, that's kind of what they are. Someone's asked, are there templates for these on Sprintlaw? We offer services in terms of drafting privacy docs. We do have some templates for some basic docs, I think for a web terms and conditions, which is not explicitly required by the Privacy Act, but another good thing to have. And as I think my colleague mentioned, we're going to be releasing a few new templates on the Sprintlaw membership probably in July or August. Awesome. So I think that covers everything. And if you also have any feedback, we do these every month. So would love any positive or critical feedback on whether people found this useful. Thank you all so much, and we will see you next time.